So in my testimony today, I'd like to focus on three main issues. The first is that the current preventative paradigm of countering terrorism is fraught with peril because it risks infringing on First Amendment protected activities and misdirects limited law enforcement resources away from criminal activity. The second issue I want to focus on is that the laws prohibiting material support, as was previously discussed, need to be reformed because they are so broad and so vague that they effectively criminalize First Amendment activities and protected advocacy and legitimate humanitarian aid. And finally, I want to make note of about the current discourse on homegrown terrorism, as this is currently in the media quite a bit, and argue that in effect it facilitates the selective enforcement of counterterrorism against Muslims while non-Muslims such as Joseph Stat or Jared Lee Loughner commit acts of terror undetected, which thereby endangers our collective public safety. So focusing first on the preventative paradigm. As a matter of law, it is unlawful for the government to investigate and prosecute individuals solely based on their First Amendment protected speech, association, assembly, and religious practices. And that's for good reason. Our founding fathers were cognizant that when government exercises its authority to quash political opponents or dissenting views, our democracy is threatened. The founding fathers were also keenly aware of the devastating effects of state entanglement in religious affairs, especially when the state disfavors one religion over others, resulting in a stigmatization and the shunning of the religious congregants in the court of public opinion, or worse, in a court of law. So what brings so many of us here today from different races, different creeds, different religions, is a common commitment to those fundamental American values of free speech, free association, free assembly, and the right to practice one's religion freely, regardless of the popularity of such political beliefs or religious practices in the eyes of society or in the eyes of government. Because we all know that once the government is permitted to persecute a particular group based on protected constitutional activities, it is only a matter of time before other groups are targeted. And we've already seen that in Chicago and Minneapolis just a few months ago and today. So many of us here today have repeatedly expressed these concerns to our government, including myself. But unfortunately, we are blindly dismissed with boilerplate responses that the American government does not counter terrorism in a manner that violates the Constitution. And while government spokespersons may indeed genuinely believe their statements, the actions of the state prove otherwise. As others will discuss in today's events, there is no shortage of cases that raise serious concerns that individuals are being targeted for investigation and prosecution based on their unpopular political beliefs or religious practices. And in the cases when individuals are found to have violated the law, the punishments are often extraordinarily severe compared to others who have committed similar acts. And so the only apparent difference between the cases is the religious and racial background of the defendants. Unfortunately, such disparate treatment across racial and religious lines is not new to the American criminal justice system. As we witnessed in the purported war on drugs, where African American defendants receive sentences nearly 100 times longer than their white counterparts, we are seeing similar disparities against Muslim, Arab, and South Asian defendants. These disparities are not limited to selective enforcement of terrorism laws, but continue after conviction when Muslim prisoners are swept into virtual dungeons called communications management units. Their condemnation to these punitive detention centers occurs without due process or public transparency to allow for legitimate challenges to the government's basis for such severe post-conviction punishments. Now, related, or a key component of the preventative paradigm are the laws on material support, prohibiting material support to terrorist organizations. And the recent Supreme Court ruling in Humanitarian Law Project v. Holder brought to light the flaws in the laws prohibiting material support. The case was brought by a former federal judge and numerous established American advocacy groups who sought to train the PKK and the Tamil Tigers on how to stop engaging in violence and resolve their disputes peacefully through the United Nations and other international tribunals. Unfortunately, the Supreme Court found that their efforts violate laws prohibiting material support to terrorists. The ruling failed to differentiate between aiding terrorists engaged in violent terrorist activities and participating in legitimate advocacy and democracy building. As a result of this highly problematic ruling, it is now illegal for Americans to teach groups to put down their guns, pick up their pens, invoke international human rights law, and seek redress through international tribunals such as the United Nations or the International Criminal Court. This outcome contradicts our nation's stated commitment to international human rights law and sends a message to the world that we as Americans are not serious about human rights and peaceful conflict resolution. Moreover, the ruling undermines American civil society as it limits international peace-building efforts to politicized government programs sponsored by the Department of State or the USAID. And because the independent American nonprofit sector plays a pivotal role in international peace-building efforts and humanitarian aid to impoverished civilians in conflict zones, the HLF ruling could be devastating on human lives abroad. Now, another adverse consequence of material support laws is caused by the targeted and selective enforcement against Muslim charities. As a result, there has been a significant chilling of charitable giving among Muslims in America. Muslim donors are scared to give to Muslim charities because they fear they will be prosecuted for material support to terrorism, even though they did not intend to support terrorism. And they fear their donations will invite government scrutiny and harassment in the form of tax audits, extraneous immigration checks, denial of citizenship applications, requests for FBI voluntary interviews, additions to watch lists, and surveillance. And all of these are what we call collateral adverse consequences and are meticulously detailed in the 2009 report by the American Civil Liberties Union entitled Blocking Faith, Freezing Charity, which I highly recommend that everyone in the audience read. Now, a particularly troubling aspect of the closures of some Muslim charities is the government's admission that they never gave charitable donations directly to foreign terrorist organizations. Rather, as the law stands now, the mere giving of humanitarian aid to local nonprofits abroad that are not designated as terrorist organizations can make American charities and their officers guilty of material support to terrorism. Indeed, the legal implications are so serious that 20 of the largest nonprofits and foundations joined in filing an amicus brief filed by my colleague David Cole at the Georgetown Law Center in the Holy Land Foundation case. Among the giants in the nonprofit sector who signed the brief are the Carter Center, the Rockefeller Brother Fund, the Constitution Project, Grantmakers Without Borders, and the Samuel Rubin Foundation. And the brief asked the Fifth Circuit to interpret the material support statute to at the very least require proof of knowledge that the money is going to a designated terrorist group. Because otherwise, even if the group that directly receives the aid is not designated, one could be exposed to liability and prosecution. Now, going a little bit more specifically with the fear of collateral adverse consequences, which is really important because oftentimes the government responds to these types of points by responding, well, we've never prosecuted a donor. We only go after charities, which is generally true. I think there's a few exceptions. The problem is that even if you don't get prosecuted for material support, there are collateral consequences, and the Muslim community is very cognizant of these consequences. For example, once the government knows about the Muslim donors' identities after they raid the charity, the donors will become targets of heightened scrutiny and investigation. Many fear that the government uses the donor list of charities that are either designated or even just under investigation as a starting point for investigating terrorism, even if they have no individualized evidence of wrongdoing. Hence, donors become subject to burdensome tax audits, denials of citizenship